Yeah. Okay, and more news. We have the Supreme Court to rule on cannabis uses and guns. So now we're gonna see how the cannabis related to the guns. So go ahead and check it out, and we'll talk about it after.
Good news. Today, we have a Supreme Court case that could get rights to cannabis users for the first time in decades and undo some of the congressional overreach when it comes to the plant. I've got an amicus brief from the normal legal committee. Shout out to those lawyers. I'm Attorney Tom Howard asking for likes and subscribes for the case of US v. Hamani. Let's dive into it with our slides. Oral argument is set for March 2nd, so stay tuned because we'll have more stories on this. So what is the case of US v. Hamani? This is the case of gun rights and cannabis use. Do you have the right to use cannabis as an adult in America? Turns out, no, you do not. Let's find out why. It is in the USC, that's the United States Code. Here's the statute, 18 USC 922 G3. It is unlawful for any person who is an unlawful user or addicted to any controlled substance to possess or in effecting commerce any firearm or ammunition. Of course, because cannabis is still, as of February 2026, a Schedule I substance, any use of it turns out that it is abuse, which is just terrible. So as a result, if you use cannabis and are an adult in the United States, it is illegal for you to have a firearm. Is that congressional overreach? I tend to think that it is. Let's go over the procedural history of the case. This basically means what has happened so far. A district court dismissed the indictment. That was the initial ruling. They appealed to the Fifth Circuit, and the Fifth Circuit affirmed that dismissal, the appellate decision. Now, this is when you go up to the Supreme Court, and they've granted certiorari, which means that it is exceedingly rare. And we've discussed on this YouTube channel before, granting happens to like approximately 1% of the cases that get this. And why? Typically, it's because there is a split in the circuit courts, and that's what we have in this. We have a split in the circuit courts, and so that Fifth Circuit affirmed the dismissal, creating a split. What is the law? Is the law what the statute says, or is the law illegal? And that is what the Supreme Court will answer. Can't wait to tune in to the oral arguments. Here's the constitutional test. Does the Second Amendment's plain text cover the conduct? Yes. Possession of firearms. And then the history. Is the nation's restriction consistent with the historical tradition of firearm regulation? No, because this is overly broad. This is all possession, as opposed to like if you were a cowboy and you happened into, a saloon. There's a rule in the saloon. You can't get drunk while you have your peacemaker strapped to your hip. Makes a lot of sense. That is a time, place, manner restriction on your Second Amendment rights. But when you leave the bar or sober up, then you can get your gun back. That's not what this statute says. As you see, disarmament is tied with dangerousness, proven with process that pose a credible threat to physical safety. We don't have that here. We just have a blanket ban. Of course, the cannabis users, they are the people. They could be medical patients, parents, vets, workers. Many people use cannabis. Users are not aliens or enemy combatants. They're just ordinary citizens. And therefore, the burden on this is going to shift to the government to justify the ban based on history. I don't think they're going to be able to do it, which is fantastic. We will actually get some rights. It's not like Congress is doing anything. And who knows how long Schedule 3 is going to take. This deck is based off of the normal legal committee's amicus brief. It is a historical tradition of silence when it comes to cannabis. As everybody knows, our founding fathers grew the cannabis plant. They called it hemp. It didn't get you high, but they made a whole bunch of stuff out of it, like their clothes and paint and other things that you would need on a sailing ship or to write the Constitution. They even cite that colonial Virginia laws required hemp cultivation for the industry. And in 1851, the Pharmacopoeia listed cannabis in it as a drug, and it stayed there until 1952 when it was finally taken out because of, it being called marijuana and being banned. Again, this is a scope issue. And so has the intoxication been prohibited, or did you just remove their Second Amendment rights entirely? Section 922G3 removes their Second Amendment rights entirely. And that is the congressional overreach that we hope the Supreme Court overturns when they issue their opinion, probably in the last week of June, maybe earlier, but they're taking the oral argument in March. For example, we've gone over this. Temporarily drunk, you can have your firearm access restricted, but that is a temporary. That's not an indefinite. It's not a total ban. It's more of a public carry. Like you can't have your guns while you're getting drunk. Reasonable restriction on your Second Amendment rights. Once you sober up, here's your gun back. Okay, what's the Rahimi process? Well, that's another case, another firearm law case, pretty recent, 2024. That was U.S. v. Rahimi. And so you could have a temporary restriction on your individual's right to possess a firearm, but that's only after you've had the opportunity to figure out whether or not you pose a credible threat to the physical safety of others. And they find that credible threat, you can maybe temporarily disarmed. Now, that's under a slightly different section of 922G. It's 922G8. This is 922G3. Is there a presumption of danger simply because you use cannabis? There's no court finding, and you've been disarmed categorically. So that might be a distinction that the Supreme Court will try to bring and invalidate this particular section of USC 922 G3. So this G3 section completely disarmed because it's a Schedule 1 substance that any use is defined as abuse against Schedule 1. That's completely different when you actually look at the substances. The justices giving rights to cannabis and making a distinction between alcohol and cannabis, and drinkers are not categorically disarmed, but because you use cannabis and it's a Schedule 1 substance, even though you live in a state where it's completely legal under your state laws and maybe even have a medical card. So it's two layers of state legality in that regards. And maybe the Schedule 3 might make it a third layer or a new layer of federal quasi-legality. Doesn't matter, completely banned. And as a result, that might be that overbreadth that the Supreme Court will use to strike down this provision to categorically ban people who have used Schedule 1 drugs from bearing arms. Let's also dig into a different aspect of this. What about prescription drugs, opioids, benzos? Because they have the ability to be prescribed, those people that have those drugs don't have their Second Amendment rights infringed. Now, maybe they aren't allowed to be overly medicated and use their gun, or at least in public, but with medical cannabis, completely lost their guns because of the text of the statute itself. Is there a difference between impairment and status? And so status bans are what they are zeroing in on with this case, as opposed to impairment bans, which have been generally found to be constitutional. Simply because you use cannabis and it's a Schedule 1 drug, and then because of the way the law is written, that immediately invalidates you, doesn't mean that is a constitutional law when it comes to your Second Amendment rights. What about the policy argument of it? Congress, they passed these bills, and one of them is this section 922G3 that we're discussing, but also another one has an appropriations rider that says the states are allowed to have medical cannabis programs, and the Department of Justice will not have any funds to interfere. Very strange. And then what about the executive? So we go to a different branch of the government. And the executive, the past two administrations, has called on the Attorney General through the Controlled Substances Act's mechanics to reschedule cannabis. That is pending, but it's working its way through the process. So why is the government simultaneously disarming cannabis users while providing them certain federal protections, at least if they're a medical user as opposed to a recreational user? That is the real question that this case should answer. I'm looking forward to seeing what happens. And let's think of how broad this status ban really is. Numerous states, half of them, allow adult use cannabis. 4 and 5 of them allow medical use cannabis. The federal government defunds itself from enforcing the nation's cannabis laws for those medical patients. So this status ban is very, very broad. It applies to tens of millions of people. Of course, they threw in a little bit of irony in the history. The government used to advocate cultivating hemp during World War II because we needed it for industry. Now, especially after the new hemp ban becomes effective later this year, they're stripping those people's rights. To sum up, the people, of course, are the cannabis users throughout the United States. They are protected citizens. In the void, there is no tradition of disarming this class of people, not maybe criminalizing them, but not disarming them. The mismatch status is not intoxication, permanent is not temporary. And as a result, that aspect of the statute is probably overbroad and infringes on your constitutional rights. Same with science. The cannabis is not dangerous per se, so the violence proxy fails. There's lots of studies that have been done on how safe the cannabis plant is when it comes to your risk of overdose and abuse. Not that the federal government cares, at least if you read the law when it's a Schedule 1 substance. And then what are some outcomes? They can affirm then that we hope that they affirm what the lower courts did and dismiss the case, hold that 922G3 is unconstitutional as applied, and rejects status bans absent proof of intoxication and danger. For example, had the person been pulled over while smoking a blunt going down the highway with a gun in the seat next to him, that probably might have been all right because they have proof of intoxication and danger. In a car, smoking with an open firearm there, meh. But if it's more like the other cases, we did one with the people from New Mexico earlier this year. I'll put that video after this one because we've covered this subject before. That's why there's a split in the circuits. Just because somebody has used cannabis within even the past 24 hours doesn't mean that they are in danger or intoxicated at that moment. And then maybe there'll be a narrow ruling and they'll have a law to require contemporaneous intoxication while armed. The courts tend to not interpret words that are not there, so that might be too far for them. Or they could uphold it and say the lower courts were wrong and they accept this dangerous class of millions, tens of millions of marijuana users throughout the United States. That just seems, well, absurd. There's a small closing thought based on the brief of the amicus curiae. I don't speak Latin, so I don't think I'm pronouncing it correctly. However, I always like to remember that no one alive spoke Latin like they did in the Romans. We don't have any recordings of that. Who knows what they sounded like? Constitution requires historical evidence, not modern prejudices. There's no tradition of disarming peaceful citizens for using a plant, and it should stay that way. So tune in to cannabis legalization news in the coming weeks as we cover the oral argument, and then in the coming months as we cover what decision the Supreme Court hands down. If you like this stuff, don't forget to give us a like and subscribe. We'll come up more often in your feeds, and the next video will discuss another case with similar facts that has to do with your rights to bear arms.
Okay, tell me what you think about what Tom Howard just said. How you feel? What you think? Hey, it is what it is. So be sure to go on Cannabis Legalization News, like and subscribe. Let them know Wacky Leaf sent you. Yeah, questions, comments down low.